everyone, and welcome back to IP Shorts with another new video. So in today's video, we will discuss an important case, that is Krishna Kishore Singh versus Sarla Saraogi and others, and it is a very important verdict pronounced by the Delhi High Court bench of Justice Sanjeev Narula on 10th of June 2021. This judgment is based on personality rights of an individual. So let's have a look at the facts of the case. So the plaintiff, that is Mr. Krishna Kishore, is the father of late Bollywood actor Sushant Singh Rajput. He filed this plea seeking an ex parte ad interim injunction from using his son's name, caricature, lifestyle in the forthcoming films like Nyay, Suicide or Murder, and Shashank, contending that any such publication, production, or depiction would be an infringement of personality rights, right to privacy, which includes right to publicity, and cannot be undertaken without prior approval of his legal heir, and a violation of right of fair trial under Article 21 of the Constitution of India. So the plaintiffs in this case contended basic three things. The first contention of the plaintiffs was that there was a violation of celebrity rights or the right to publicity. So celebrity rights have been acknowledged for the benefit of those who have worked hard to be known as distinguished personalities. It gives them the right to publicity, which allows them to control the commercial use of their identity and entitles them to the money that arises from that fame. Such celebrity rights are assignable and licensable for commercial benefits. So in the present case, the plaintiffs contended that the public perception of the plaintiff's son, that is Sushant Singh Rajput, is of tremendous value. After his death, the public at large cannot be permitted to make windfall gain through commercially exploiting the persona of the deceased. The second contention of the plaintiffs was that there was a violation of the right to privacy. So, right to life under Article 21 of the Constitution of India includes the right to privacy of not just one's own but of one's family as well. It is the case of the plaintiff that any depiction of his own or his son's life is violative of the plaintiff's right to privacy. The third main contention of plaintiffs was that there was a violation of the right to free and fair trial. So since CBI investigation into the demise of Sushant Singh Rajput is presently underway, the fictitious portrayal of the circumstances surrounding his death will prejudice the case of the plaintiff, and on the other hand, the defendant's contentions were that firstly, while accepting the celebrity status of the plaintiff's deceased son, defendant stated that the right of a celebrity infringed only in case they are identifiable as a part of an artistic work and they have denied the use of Sushant's name, image, or style of delivering dialogues. The second main contention was that there is plethora of material available in the public domain on the life and death of Sushant, and thus already the material has become public and has been admitted by the plaintiff also. He also states that as the mysterious demise of the deceased and the consequent investigation has already been discussed at large on the news and the media, there cannot be any question of privacy over that which is already in the public realm. Moreover, the right to privacy of a celebrity extinguishes upon his demise. Such a right lives and dies with the deceased, and thus the plaintiff cannot attempt to exercise a right which has already ceased to exist an year ago with the demise of Sushant. The third contention was that the film is neither a biopic nor a biography of the plaintiff's son. So it is not even based or concerned with his life, but it is instead a fictional rendition with creative dramatization of true events, generally surrounding the lives of film stars or TV celebrities who have reportedly passed away due to unnatural causes, and the details are widely available in the public domain, made with creative liberties. The next contention of the defendants was that the goodwill and the reputation earned by Sushant Singh Rajput during his lifetime cannot be inherited by plaintiff like a movable or immovable property, and the plaintiff has failed to made out a prima facie ingredient of passing off or misappropriation of the personality of the plaintiff's son. It is for this reason that even under the Copyright Act 1957, no one can claim copyright in actual facts or historical events. So the court, after analyzing the arguments that were presented by both the parties and briefly examining the works that have to be injuncted in the case, stated that there is no express statutory recognition of publicity, personality, or celebrity rights in India. Nevertheless, on the basis of rights that are asserted in the Copyright Act, it becomes relevant, but it does not anywhere define the term celebrity. And the most relevant definition that we can relate to is thereunder of author and performer and their associated rights, who may not necessarily be celebrities. So in another sense, the plaintiff claims a copyright over the life of Sushant Singh Rajput. However, under the Copyright Act 1957, the facts which are historical, biographical, or news of the day cannot be copyrighted, as they are a part of the public domain and available to every person and involve no originality and creation, which lies at the heart of a copyright protection. So on plaintiff's claim of passing off, the court held that a passing off action is initiated to safeguard the plaintiff's goodwill from another who is designed to trying to mislead the public that his goods or services are that of the plaintiff. So in view of the facts that we see in the case, the specific disclaimer of the defendants before the movie, the court stated that it prima facie does not find any element to hold that the film would lead the public to believe that it is a true story or a biopic that has been authorized or endorsed by the plaintiff himself. So once the disclaimer is included at the beginning of a cinematograph film, any apprehension that the plaintiff has about passing off the film is of biopic of SSR will be put to rest. So plaintiff has failed to satisfy the three-step test for grant of preemptory injunction to restrain exhibition of the films. So the court dismissed the avertments as to rights of free trial, passing off, and hence dismissed the petition. I have also attached the original judgment in the description below, so you can also access it from there. And do not forget to subscribe IP Shots for more and regular updates. Thanks for watching. Bye-bye.